Hello and welcome. I'm Jennifer Stowell. Idea to IPO has been holding tech startup events in Silicon Valley for many, many years. We launched officially on February 1st, 2010. At that time, we had no members and no events on our calendar. At this stage, we have over 100,000 members among all of our meetup groups all around the world. We have organized, promoted, and produced over 2,519 events. By any standard, by any measure, we are the most active, the most prolific startup event organization in the history of Silicon Valley, bar none. We organize venture capital panels, legal workshops, networking events, and more. These days, we are 100% online. We hold an event nearly every day of the week. Check out our schedule at idea2ipo.com. Our featured speaker today is Jason Putnam Gordon, one of the top venture capital attorneys in Silicon Valley, and he is passionate about helping entrepreneurs succeed. Ladies and gentlemen, Jason Putnam Gordon. Jason, take it away.
Super. Thank you so much, Jennifer. It's a pleasure to be here tonight. Welcome to everybody. I am in San Francisco, California, and today we're going to talk about how to do a venture capital financing, one of my favorite topics. Before we get into it, we're going to run through a couple of ground rules, and I'll let you know how tonight's presentation is going to unfold. First and foremost, if you were unaware, tonight's event is recorded. Upside is, if you miss some or all of it, you'll be able to catch it later. So long as you've registered, I will follow up with an email with the slides and also with the presentation a little bit later. Now, sort of the downside to being recorded is that anything you say may be memorialized for posterity. So please don't provide any confidential information tonight, and do understand that anything that you say, should you speak or should I read a question that you pose, will be recorded. Now, what we're going to do is I'm going to speak for about an hour or so. If you have questions, I'd like this to try and be an engaging conversation. So please use the Q&A function within Zoom to do that. It's easier for me to track. In addition to presenting tonight, I'm also running all the tech in the background. It's not that much tech, but by the time I sort of present and then also run that, I can get lost with all the pop-up windows, right? So I'm going to be monitoring the Q&A function, use that. I'll try and get your question then if it's relevant time-wise. And if not, we'll come back and we'll have about a half hour to do some Q&A in the end. Now, while I'm speaking, as we're running through the first things, what I'd like to do is I always like to get a sense for who's in the room. I've done a lot of events with Idea to IPO. I really enjoy it. One of the things that I like when we're in person is you can get a better read of the room. So fill out the survey. And that'll give me a sense, and we'll disclose who is in the room shortly. All right, so with that in mind, as I mentioned today, we're going to talk about how to do a venture capital financing. This is a very nuts and bolts conversation, and I won't wait any longer other than to say, look, today's conversation is general information. This is not legal advice for you. I'm going to give you an insight into how these financings go, maybe share with you some experiences that I've had, that my clients have had, that other folks, other startups have experienced or venture capitalists have experienced, but they're not going to be tailored for you. And they're not going to be tailored for you for a host of reasons, but among them is that what we talk about today, we'll talk about some rules, we'll talk about some exceptions to rules, but there's always exceptions to the exceptions. And I'm not going to gain enough information in today's conversation, whether it's through a question you pose, or even if we have a conversation later to give you specific tailored legal advice. So hire a lawyer if you're ready to proceed or when you're ready to proceed. But this should give you a groundwork and a framing of how to handle the issues that are going to come up. So let me tick through a few things. Here's how today's conversation is going to go. We'll start with some background on myself. We'll start with some background on you as well. We'll talk about the big picture because I think it's really important to keep in mind the context. We'll talk about that in a little bit. We'll talk about what investors are looking for, what makes a good investor. We'll talk about other considerations that you should be thinking about before you even start to, identify what your pre-money is going to be, before you even start thinking about a term sheet. Then we'll talk about how to negotiate a term sheet. We'll talk about deal documentation. We'll talk about the diligence process, closing and post-closing issues, and then we'll talk about common pitfalls and traps for the unwary. That is a lot. You're going to get a lot of bang for your buck, in part because you haven't paid anything, and Polsinelli, my firm, is sponsoring this. But the other thing is that it's going to give you a good sense as to how these financings run, and it'll give you a sense for the issues. So I'm a venture capital and emerging growth company attorney. I've been practicing law since 2005. I'm with Polsinelli, LLP here in California. We've got approximately 900 attorneys in about 25 different offices throughout the US. My office is in San Francisco. I also work in Silicon Valley. I've been working in the Bay Area since 2007. I work with companies throughout the United States and also the world. And that's in large measure because if you are in tech or venture, you're going to end up touching Silicon Valley at some point. And that's where I am. And then, a little bit of background about myself before. So I've been practicing for a while. I was a really large firm, started my own firm, ran that for a while because I have a little bit of the entrepreneurial bug myself. And then eventually ended up back at a large firm again because that was the best way that I could help my clients, given the scope of services that startups and technology companies need. But I love working with entrepreneurs, serving as their outside counsel. It's so exciting to be with them, to help guide the course of the ship and to see it grow. So I want to find out a little bit about you. It looks like we've got a good sized room, and of that, we've got about 75% of the people have provided input. So let's take a look. All right, so we've got 30% here in the Bay Area. We've got, I'm going to share these results. 30% in the Bay Area, 2 are outside of the Bay Area, but in California, we've got almost 20% here in the US, another couple of folks from the rest of North America, some folks from South America, some folks from Europe and Asia, and a couple of folks from Africa. And then let's check out who, and I would say that just going back in terms of location, that's probably about a typical mix here. Usually actually we see a little bit, a few more people in from the Bay Area, but I'm not surprised. Maybe folks are out skiing or still on holiday. So if you look at it, we've got a room full of entrepreneurs, which is very exciting. That's directly on target for who this is going to be beneficial for. We've got 44% of the people in the room are first-time entrepreneurs. Congratulations. It's very exciting. We've got a good number of serial entrepreneurs. And one of the things that I sort of miss about having these virtual events is that usually when we do an in-person event, I can call on those serial entrepreneurs and we can have just a brief discussion on what they learned in their first endeavors, and how entrepreneurship is really an amalgam of many different skills, and how knowledge and application make you a much better entrepreneur. It looks like we've got a couple of VCs in here. We've got a few students, and then we've got some folks at a large company, and then some others. So that's terrific. I'm going to stop that, and then we'll move right on with the program. All right, so what I'd like to do is just in almost all my presentations, especially because we've got, I think 44% of the people are first-time entrepreneurs, is just zoom out for a minute and take a look at the big picture. And, the big picture here is to build a company and grow it. Venture capital is one means to do that. It's not the right fit for everybody. It's not the right fit for every company. And when in a different presentation, we kind of unpack that and explore a little bit more. But for today's topic, we're gonna presume that it is the right fit. And let's talk a little bit about the way that the typical path, the typical financing path. So typically there will be a few founders or a founder. They'll come out, they'll need to build a prototype and put together an initial team. That's in the sort of seed stage. That's in the angels triple F, friends, family, and fools, and some initial seed capital. And there's no revenue at that point. And it is where most startups fail, okay, for a host of reasons, which we don't have time to go into today. But then after that, as they start to have a product or a service together, and they're also beginning to prove it within the market, that is, people want to buy that good or service, then it's time to scale. And that's what we're talking about today. We're talking that right after that sort of revenue line sort of breaks over zero, and then sort of really starts to sharply curve up. That's when you do your initial, sort of Series A financing, if you will. And you'll see that there's a typical path in terms of first, second, third, A, B, C, and subsequent financings in order to get that capital, in order to scale the company. Scaling the company means usually adding people, adding teams, adding marketing, all sorts of things, so you can be able to capture sufficient market share and build that company and scale it. So a financing in and of itself is not an end. Even if you do one, if you are truly a company that is well poised and appropriate to be raising venture capital, then you're going to be doing others. And I'm just ticking through my slides here. And the goal is, as you raise capital, as you acquire customers, as you generate revenue, you're going to increase the value of the company. And at some point, you're going to have an exit. You're going to have an exit either by IPO, which is relatively uncommon, or more accurate, or more often, it would be some sort of merger acquisition event. And that's the chance. That's what we call a liquidity event. It's the opportunity for people to turn their shares of the company into cash, or get liquid, if you will. I'm going to take a quick pause there and check the Q&A and take a sip of water. See if we've got any Q&A. None yet. All right, let's keep cruising. All right. So let's talk about what VCs want and who makes a good investor. And this does kind of dovetail with the topic of, are you putting together a business for which it's appropriate to seek venture capital funding? Because again, not all companies are. So I think it's helpful, especially for first-time entrepreneurs, to just get a high-level view of what's going on the other side of the table, right? Because in order for you to really be able to negotiate and negotiate well with someone, you need to understand what motivates them, what moves them, what makes them tick. So what VCs do is they put together a fund, and there are LPs, those are limited partners in their fund, that supply the capital. And then their job, they've got a fiduciary duty to those partners to deploy the capital and get a return, okay? And sort of commonly, we're talking about sort of a 20 to 30% year over year return. So basically money is sort of 3x over the life of the fund. And to do that, they place a number of bets. Now, those bets, I call them bets. Lots of other people call them bets. But when I say bets, I'm really talking about investments. So they make investments in certain companies with the goal of being able to ideally sort of 10x their money in roughly 5 years. That's to make the math work out, because they know not all of the companies are going to be successful. In fact, it's going to be, they're only going to have a couple of home runs, and that's what's really going to move the returns within their portfolio. Now, that's sort of high level what you'd expect from a fund. Strategic investors have different goals. They may be trying to facilitate the development of technology in their space so they could eventually acquire it. They may be trying to facilitate, maybe trying to build basically future markets so that people will want their goods and services later. So the companies will grow, and they'll need to use the sort of corporate VCs goods and services later. And on the company's objective side, ideally, you want what we would call smart money in the door. So that's not just dollars, okay? Because these relationships are supposed to be long-term. ideally they're positive, and they are, and by positive, I mean, they will bring not only dollars to your company, they will be able to provide strategic advice, be able to help you source employees, be able to help you source and land relationships with customers, and other types of things along those lines. So you need to be careful, and we'll probably talk about this a little bit later, but you need to be careful about who you allow to invest in your company, should you be fortunate enough to be in the position to receive investment. And you want good long-term investors. So those are folks where everyone's interests are aligned. We've got some comments about hearing that investors invest in people and not products. And so let's talk about that for just a brief moment. That is absolutely true. And it also sort of depends upon where in the life cycle they're making their investment. Okay, so kind of the earlier on it is, the more they're investing and they're making the bet on the people and the team. As you start to move through to, let's say, a traditional sort of Series A, where you've already got a product and it's already doing well or already starting to get traction in the marketplace, you've proved that concept in the marketplace, then they are looking to invest in people. But the real return is being able to pick a company where you've got the right people who can manage it and can manage that growth. So I think, and then as you get later in the life cycle, then it really does become more sort of about some products, or being able to, invest more kind of in the business and less sort of in the people. I answered that live. How rare is it to borrow from banks, or to not start or not? So this is the issue here, at least. And when I'm speaking today, I'm going to be speaking from my own experience, where, I am here in the Bay Area. I work with companies throughout the world. But of course, my experience is colored by being predominantly in the Bay Area. Banks will lend to you if you've got hard assets. Most startups don't have any hard assets or even any revenue, which is also a requirement when they get started early on. And so you may be able to get some capital from a bank, especially if you were to personally guarantee it. But with these high risk businesses and endeavors, it's usually not a great move for the entrepreneur. At least here in the Bay Area, at least in the US, the sort of ethos is, better to try and to fail and pick yourself up and learn and then try again than to have never tried. And that's sort of different. There are other communities, other places in the world where you need to be successful in the first shot. So banks are not usually a great source of capital for first-time entrepreneurs out here. All right. So let's talk about some structural issues first. So let's say you've identified, potential VCs for who you think might be good investors in your company. You need to make sure that you've got the right company structure. So because VC funds are set up as limited partnerships, that means that they are pass-through tax entities here in the United States. That means that the losses and profits of their portfolio companies, as the companies they've invested in, get passed through to their limited partners. Essentially, you need to have a corporate blocker in place so that they don't have the accounting nightmare of, 5 of the companies had successful exits, 10 are running deficits. It would be a nightmare. So that moves us typically to a C Corp structure. And then usually it's in Delaware, because we have, because Delaware is known for a few things, which include more protections for directors and officers. VCs put directors on the board. Very good, well-developed corporate case law, and their Secretary of State's office is also pretty great. And then there are also some other corporate law features which sort of make it easier for the VCs to have some certainty that they'll be able to get a liquidity event if it's appropriate. Now, doing some of that, getting all that stuff cleaned up is going to be pretty important. Having corporate company documentation in place is going to be very critical, because VCs are investing in a business. They're not investing in a lawsuit. Now, let me unpack that. So they are, they want to make sure that their dollars are not going to go into either defending a lawsuit or pursuing a lawsuit, absent certain circumstances, special circumstances, and unique cases. So what are they looking for? Well, they are looking for documentation tying all the intellectual property that the business needs to run its business to the company. Okay, so those are various IP assignment agreements with the contractors, with the employees, with advisors, with other outside vendors, making sure that if there is material that is important, intellectual property that is developed, that is going to be necessary or appropriate for the business in order to function and to become profitable, all that needs to be tied in and documented. Now, some of the other important things, or another important thing is, first and foremost in one of these deals, what you're doing is you're selling a piece of the company. Okay, now, you can't really sell a piece of the company unless you know how many pieces are out there. And so what another really important thing to make sure is fully documented is making sure you've documented who or what has what portions of the company. Let me unpack that for a second. In a corporation, the owners of the company own stock. They don't own percentages. Now, we get to percentages by taking a numerator and denominator, figuring it out. That's not the topic of today's conversation. So suffice it to say, there needs to be documentation around who owns what shares in the company, whether or not there are any securities that are convertible into shares. That would be your safes or your convertible notes, whether there are any warrants or options or anything else that basically can get turned into stock. All that needs to be documented. I see that my Q&A is lighting up like a Christmas tree because it's both green and red. I'm going to come, I'll touch on some of these questions a little bit later or after I move through this slide. So getting that in place, making sure that the founders have the appropriate kind of vesting schedules, making sure that the founders, to the extent where necessary, file their 83B elections, all those things are pretty important. Vesting is a concept that if one of the founders or one of the other folks or one of the other employees who has it, and it's going to be necessary for other employees and contractors, if they were to walk away from the company, they don't walk away with all their stock. There's kind of nothing worse than having the company owned a third, and then somebody walks out the next day, right? The company is only one day old, and all the stock is, and a third of the stock is out the door. There are other important things in terms of some transfer restrictions for the founders and other employees, so that they can't transfer their shares to competitors if they were to get upset later. But that's kind of it. In a nutshell, the really big pieces are making sure all of the intellectual property is tied into the company. All of the ownership stakes have been well documented. There are not other sorts of legal issues that are going to pop up and cause a problem or a lawsuit, like employment law issues, or in terms of documenting people as contractors instead of employees. And we can talk about that risk assessment a little bit later if we've got time. You're not infringing on other people's we're not knowingly infringing on other people's trademarks or intellectual property. You're not in some sort of dispute with one of your major vendors or suppliers, and making sure they're not investing in a lawsuit, to say the least. Which brings me to the next point, which is modeling various rounds. Key point to drive home today, the point of this transaction, again, is to make sure, the key to the point of this transaction is you're selling a piece of the company. So you want to make sure how many pieces you have, how big they are, and what it's going to look like in the future as you do another raise and another raise. Because if you think back to, I think, slide 2 or 3, right, where you had this sort of upward curve, that is the typical trajectory. You'll be doing a B round, a C round, and you're going to get diluted in that. And maybe we have some time to talk about dilution a little bit later. But it's critical to model this round, the next round, and ideally maybe even the following round, because the decisions you make today and when you document all of this is going to set precedent for future rounds. I can't tell you how many negotiations I've had where, there's been a term, we're at the B round or something along those lines, and the other side will take the position, well, that is the way that it was, or we will take the position, well, that's the way it's been in the documents. So any move you make now is precedent for the future. It's not to say it couldn't change, but there's some inertia. So it might take some effort, it might not be possible. All right, I'm going to pause there and maybe start to work through some of these questions if I have time before we move on to how to negotiate a term sheet. We have our company registered since 2012 in Palo Alto and a German headquarter in Germany, invest VCs in Germany and the US. Yeah, so there are definitely a lot of cross-border VCs. And happy to have a conversation with you afterwards if you see if we know anybody in common. VCs do not seem to be looking for early stage MVP, minimum viable products, to identify synergies with growing companies, resulting in the valley of death for those early stage ones. This kind of gets maybe to a more philosophical point. I have heard it be explained, and I think it's probably true, that one reason why tech and venture is so exciting and potentially so profitable is that large companies don't do a great job in innovating. Okay, they've got great, bureaucracy. They've got a certain type of person. This is not a bad thing, but people who are sort of wedded to the status quo, maybe not quite as innovative, and so startups oftentimes fill that gap. And so it's true, and that's kind of true on a host of levels. So VCs are typically so many VCs, they'll come to, there are some that specialize sort of down market in sort of seed stage companies, and they are betting on the team. They're betting the team are going to sort of figure out a solution. They're not necessarily quite as drilled in or dialed in on the MVP, the minimum viable product. But most of them are looking to, if you're really looking at sort of a traditional Series A, you're looking at, there's already a minimum, there's beyond sort of the minimum viable product. That product has been out in the market and is doing well, and they're looking to put in money so that you can scale and capture a lot more revenue much more quickly. We are a cash profitable and unique single sole source marketing company. We're looking for investors that bring money and expertise in scaling nationwide. Help on this. So my email is jgordon@pulsanelli.com. It's at the beginning of the slideshow. You'll get it at the end. For these types of questions, I keep office hours on Fridays and Friday afternoons. I'd be happy to set up a call, just to have a general conversation, see if there's anything I could do to help. It's a Delaware corporation. Okay, I don't know what that is. When developing a physical electronic product, would you recommend to secure a patent before the design is set to manufacturers or when the prototype is built? I would punt that to one of my IP guys, but there's also is something that's pretty important. You get a provisional patent for less. So I would be looking at figuring out, is it appropriate to do a provisional patent at that point in time, because they're substantially less expensive than a full-blown patent by like an order of magnitude or a half. How do you calculate the right share presentation for investors and VCs? That is beyond the scope of this topic, but there is another, but email me, I got another presentation where we go through that. What if we have already formed an LLC? What is the best approach for LLC-based funding approaches? If you filed an LLC already, it's not the end of the world. What we would do is we would take a look to see what's the optimal time to change. If it's early enough, it might be to change right away. If it's early enough, it might be okay to just scrap the LLC and form a new co and just start literally from scratch. Otherwise, sometimes it's appropriate to wait until at or just before the investment to make that switch. But there are there are mechanisms you can use, mergers or conversions, depending upon what state you're in, that make it possible to change. I have an LLC. I'm not sure if a SAFE is fine for an LLC. Your standard SAFE is not. They need to get changed substantially. How is IP documented so the original inventor gets credit if someone else claims they had the idea first? That's about filing with the USPTO. So you got to file that provisional patent, or you got to file a regular patent. And I would kick that over to my IP guys. If you've got a question and you want to talk to an IP person, I can put you in touch with one. I have a minimum viable product, but confused if it's the right time to start approaching VCs or to build the product fully to get some customers and then think about VCs. Okay, great question. I think what I would suggest, and this is not really on the legal side of things, but what I would suggest is that you need to do your homework, okay? There are VCs who play in the seed stage space, and if you've got an MVP, they may be interested in you. I would not, and so you got to do your research on them. You got to figure out, do they play at this stage? If they do, are they in this particular industry? And at that VC, who's the partner that does the kind of thing that, or who's interested in the kind of thing that we're doing? Put that list together. Start with the folks who are maybe not your top tier choice or whatever, so that you can shake out the bugs in your pitch or your approach. And then maybe approach them if you work through that. That's how I would do that. Do VCs invest in single founder startups? If not, where is the best place to find and connect with potential founders? They do invest in single founder startups. You just need to have a compelling pitch that you're going to be the right one. And I honestly don't have an answer for where's the best place to find other potential founders. You know, it used to be doing a lot of meetup events. That was a great place. There were some matchmaking services that are out there. Actually, as I think about this, send me an email afterwards, because I think I know somebody who does play some matchmaking, and that might be helpful for you. Opinion about Clerky to do the company paperwork. We do a lot of cleanup that comes out of that stuff. That's not to say you can't use Clerky, you couldn't use LegalZoom, we couldn't do something else, but I'm not gonna give an opinion on this. Do you know of any course or workshop where a founder can master the art of safes, managing cap tables, and convertible notes? Well, at least the latter three. I'm working on trying to put together a presentation and bringing in some folks to do that. So stay tuned, connect with me on LinkedIn. And when it gets up and going, I'll clue you into that. Done. All right, we're gonna move on. I keep getting hit by just a ton of questions. Where do we find the right people? Where do we find the right people to help us incorporate our startup in Delaware, since we are from South America? I could potentially be a person who can help you with that. You don't need to be in Delaware in order to form a Delaware corporation. So that's not really a difficult one. And then, all right, I'm just gonna move on at this point because we've got to keep moving. We got a lot of stuff to cover. And we'll come back to some more questions in a minute. All right, how to negotiate a term sheet. Gosh, let me just move this bar over here. It's immensely distracting. So how to negotiate a term sheet? Well, hopefully you've kind of done your diligence at this point, and you have thought about what it's going to take. You put together a business plan articulating realistically what your company's capital needs are going to be, what you're going to do with the money when you raise it, both this round, the next round, and the following round. And you've taken a look at what the dilution is going to bring to you and to your co-founders. And dilution sometimes gets a bad rap, but it is the name of the game here. And it is just a natural part of the process. At that point, you got to figure out what's going to be the biggest or excuse me, the most important term is really going to be the percentage of the company that you're selling. Okay. And that's going to be based on the valuation. So you got to get your range in there on your valuation, whether it's a pre-money or post-money. Pre-money is just the value of the company before the Series A money comes in. Post-money is just the value of the company after the funding comes in. So if you know the post-money and you know how much money is coming in, you know the pre-money. If you know the pre-money and you know how much money is coming in, you do the math, do the post-money. That's one of the biggest ones. Liquidation preference is up there and is important, although we've seen some pretty friendly, even with the pandemic and even with all that is going on in the world, at least here, we've still seen it be fairly founder friendly with regard to liquidation preferences. Those are who gets paid first in the event the company gets sold or otherwise gets liquidated, that is turned to cash. The other issues were just hotly debated and talked about and negotiated are board seats. Okay, whether or not an investor is going to have a seat on the board, what the board composition is going to look like, and whether or not there are going to be any observers there. Having the right person, the right VC to fill your board seat is great. Having the wrong one there is not good. Observer seats are not, should not just be freely given away. That is at the seed stage or the Series A stage, because because we're all human, and because a group consensus, people kind of are persuaded to go along with groupthink sometimes, even though founders and entrepreneurs are immensely independently minded, and so are VCs for that matter. But having more voices in the room that are all sort of talking and echoing the same thing can be a little bit of an echo chamber. So it can be perfectly fine and appropriate to have somebody be an observer seat, but you don't want to have 10 or 15 observers in there, and you don't need to be giving out multiple seats to the same VC. The other things that are usually, important to negotiate are protective provisions. So those are items of business, whether it's issuances of shares of stock, whether it is acquisitions of other companies or acquisition of your company, that's going to require a VC vote before they can occur. Another one that you don't want to get caught flat-footed on is who's going to cover the attorney's fees. Typically, the VCs do get some funding to have their attorney's fees and other expenses covered. At least out here, we would never see it be sort of a blank check, though. And I have seen that before in deals outside of the Bay Area. Okay, so let's talk about some of the things. Dividends, there's a range. That's not, I think there was some fear that there was going to start being cumulative dividends that would come out. That hasn't happened. Voting rights and protective provisions, we sort of hit on some of those things. Optional and mandatory conversion, that is when the preferred would convert to common. Okay, so that's why it's always important to look at the cap table, a pro forma cap table on a post-closing basis. What does that mean? So that's a model of a cap table after the deal and the financing is done, and you understand what everybody's share of ownership is on a fully diluted basis. Fully diluted basis is one of these terms of art that you'd think there'd be a standard definition, but there really kind of isn't. You always got to read the fine print on it. But usually the whole concept is anything, either common stock or anything that could be converted to common stock is considered a fully diluted basis for the denominator. Vesting for founders. Okay, how much credit for time served have you gotten? So going back to a slide that we talked about earlier, there's going to need to be founder vesting and also employee vesting and consultant and contractor vesting in place. That is, if those folks leave after the financing, they don't walk away with a chunk of the company. Now, if you've already put in 4 years, and so you're fully vested, you're going to need to reset your vesting. And the question really is how much of it. If you've already put in 2 years, you probably need to restart some of your vesting. Maybe you'll get a credit for a year or so. But getting a handle on that, whether it's single trigger or double trigger. So it's usually double trigger those days, which means in order for your vesting to accelerate, the company would have to undergo basically a sale, and you'd have to be terminated within a window of time, either before or after that sale, as opposed to if the company is sold, your vesting gets accelerated. That's negotiated, that's important. Documentation, who's drafting, whether it's the company side or investor side. Usually out here, it's the company side. And then there are, known shop and confidentiality provisions, so you can't take the term sheet around after it's signed and get a better deal. All right, I'm gonna see, so we got, oh goodness, we got a slide control here. So let's talk about deal documentation. Well, so let me pause there and talk about the term sheet. So in the process, hopefully what you've been doing is, before you needed to raise any money, you've thought about how much money you need to raise now, how much money you need to raise at the next time, how much money you need to raise at the next time. You've put together your plan of what you're going to do with that capital in order to scale it up. You've put together your list of investors, at least for the next one, and you've started to build some relationships with these people before you needed to raise any capital from them. And maybe that's because you've already got current investors who know them, so they can make an introduction, or you met them at an event, or it doesn't really matter. But you're already somewhat of a known entity. I mean, I think that is really good practical advice, which is start getting to know people from whom the VCs from whom you may try to raise money before you need it. Okay. Because that will get through that sort of initial hurdle, get you a warm intro, or get you in the door, is a better way. Now, you've done your planning, you know how much money you need to raise, you know how you're going to spend it. You've then started to go out and shop it. You've been pitching. So you've then gotten a term sheet. So before you even get a term sheet, you have a sense for, and you can articulate, oh, we're raising X number of dollars on a Y pre-money valuation. So you can start to set some expectations, and they may have already started talking about who they were getting a board seat or not get a board seat. That would hopefully result in a term sheet, which you then, work with your lawyer to mark up and send back on some of the finer points of these things that typically don't get even mentioned earlier on, like dividends per se. Now, if that term sheet is signed, or once that term sheet is agreed upon and signed, and it's usually a non-binding term sheet, except for a couple of the provisions in there, like the no shop and confidentiality. Once that's signed, then it comes time to do the documentation, which is very onerous. You can get a sense for what this documentation looks like by going to the National Venture Capital Association's set of documents. They've got a term sheet there. They've got draft form of documents. There are usually 5 or 6 main financing documents, and then a host of other documents that you got to put together. And, all said and told, by the time you kind of put it together, you got a stack of paper, sort of about that big, although things are done electronically these days. The main financing documents are the stock purchase agreement, which deals with a number of things like the actual sale of stock itself, and a number of reps and warranties that go along with that. Now, the reps and warranties are factual statements that you make in order to get the investor comfortable, and the investor gets you comfortable with the investor, that about things in the company, right? We've got X number of employees, we've got Y number of contractors, we've sold Z number of shares, only these people have, or nobody has single trigger acceleration. We haven't been involved in any lawsuits. We don't anticipate, we have no notice or no reason to anticipate being involved in any lawsuits. Additionally, in there are items like promises that you're going to do either before or after closing, which might be, the board's going to have a certain composition, or sort of things along those lines. Additionally, sort of related to the reps and warranties, there's the disclosure schedule. So that is like a document that basically says, okay, this, when read together with the reps, it makes everything true. So you might say, we have no litigation but in the disclosure schedule, you would disclose, Sally Jean was fired, last year and has sent a threatening letter, asking for wage and hours, payment for wages and hours. And sort of along with that, you'll probably have to give the investors more information to get them comfortable with it, but it's a way to make sure that the documents are all truthful. The amended and restated certificate of incorporation is the charter that gets filed with the Delaware Secretary of State, and it lays out the rights that the shares of stock have under corporate law. So various preferences in there. So the liquidation preference that we talked about would be in there. Some anti-dilution rights would be in there. The high-level board composition, right? That you'd have, one preferred director and 2 common directors, let's say, that would be in there. The circumstances under which the preferred stock would convert into common stock, that would be in there. The voting agreement is the agreement among the shareholders that does a couple of things. One, it effects, that is, it brings into being the board composition. So that is, okay, so there's one common, in my example a second ago was one preferred director and 2 common. The voting agreement would say, well, yes, one preferred director appointed by this fund, one common, and then one common who's the CEO, and then one common elected by the other common shareholders or something along those lines. Additionally, there would be a drag in there, a drag along agreement so that if the board, the majority of the preferred and the majority of the common decided to sell the company, anybody who was a part of that agreement would be required to vote in favor of it. The investor rights agreement deals with a number of things, including inspection rights by the investors for information. It deals with the registration rights in order to, where they could compel the company to do a public offering or to be able to piggyback off of and do piggyback sales. And then the right of first refusal and the co-sale agreement gives the investors sort of a secondary right of first refusal to buy the founders' shares should the founders want to sell their shares. This goes to some of the transfer restrictions that we're talking about. And sort of similarly, it gives them the co-sale right to participate in the sale along with the founders, should the founders actually sell their shares. It's a way for them to get liquid too. Now, sometimes we'll also see, and not so much if you're doing a seed deal, but a Series A deal, a legal opinion. The legal opinion goes to, whether or not a legal opinion speaks to the capitalization of your company and whether or not, all the shares were duly authorized and validly issued. And it's expensive to do. So we don't usually see it done at the seed stage, but at the Series A and beyond, it's much more common. Other documents involve various board and stockholder consents that are necessary to effect the deal, that is to bring the deal into being. Some waivers, if you've already got investors, the seed investors with certain rights, they need to give up those rights either permanently or for just for this deal. So there might be some waivers in there. Occasionally there are side letters. Not occasionally there are side letters. There are always asks for side letters, and they're frequently in there. And then I mentioned the legal opinion, and then there's frequently a bunch of cleanup work that has to get done. So I'm going to pause. Actually, let me move at least through the diligence and then see kind of where we're at. So the diligence process. The diligence really is just referring to the process by which the investors get to learn more about your company. We say they're doing their diligence. There is going to be preliminary diligence, if they're interested in you based on your pitch deck, or interest in your company based on your pitch deck, but they have not given you a term sheet. And that, can frequently that material is kind of high level, maybe sort of corporate related. And that can be put in what we would call a data room. Basically, sometimes we use Box or Dropbox, but we also have some proprietary systems or whatever, but basically just a virtual data room. They can take a look through some things. But the heavy diligence really begins after the term sheet is signed. And I say that because diligence is very time consuming for the company. For the investors, they got to pay their counsel. So they want to know, or they want to have a good sense that they want to go through this deal before they start, or everybody wants to make sure they have a good sense they're going to go through this deal before they start really investing resources in it, heavy resources into it. But in that, they're going to be requesting to see all of your documentation on various things, which usually falls into the following buckets. Corporate records, because they want to know who owns what in the company, right? Business plan and financials. They want to see that you've done your homework and you've put together a plan to take their money and to make the company increase in value markedly. Other security issuances, convertible notes and warrants and all that. Material agreements. Those are agreements that are important to the company, and they might include your lease, right? They might include some development agreement that if outside vendor worked on some IP. If you've come out of a university, if you've licensed that technology, they're going to want to see that. That's an important agreement. They're going to want to take a look at anything that has to do with any legal disputes or litigation. They'll want to make sure your IP. They'll want to take a look at all the documentation surrounding your IP. If you've got any subsidiaries, they'll take a look at that. And then there's sometimes a catch-all for other things. So let me just pause here. So let me talk about this, and let me talk about timing a little bit more. So look, a term sheet could really be negotiated in a day or two, but it really, you're looking at a week, 2 weeks, 3 weeks, 4 weeks. Sometimes it takes longer than that. Sometimes the best negotiating position you can have is to be comfortable and feel like you can walk, which might make the process take longer, but you'll end up maybe with a better deal. At the same time, you don't want the potential buyer, the VC, to get cold feet on the issue. So it's a bit of a dance. But after that, the process for doing these other things usually takes a few weeks to move through everything. If the company already has customers and already has a product, to get through everything. But it's still super time consuming and doesn't happen overnight. And the more work you do ahead of time, in terms of assembling that data room, making sure your documentation is good and there's not a lot of cleanup to be done, the faster it'll go. But it'll still take longer than you want. Typical order of operation of closing. So I'm going to move to that in a second, but let me try to answer some of these 13 questions. And I think because we are trying to answer them as we're going along, my talk will go a little bit into the 7 or in the 8 o'clock range, but we'll still have some time at the end. So how important is revenue for funding? It just matters what industry you're in and what stage of the company it is. Seed stage, usually not that important. Depends on, again, on the industry. If you're going to be doing, if you got a biotech startup, you may not have any revenue for quite some time, and you're not going to have it until after you get FDA approval. So it really just depends. It's very different than like a SaaS company. Okay, so if you're interested in having a conversation with me, exploring, maybe working together, send me an email. Happy to chat with you. If you're interested in just staying in touch with me, connect with me on LinkedIn. Happy to connect with you. And I think that's probably the most important, or the best way to handle these types of things, and whether or not there are any hourly rate questions or how we could structure working together. I'm developing a medical device. Our friends and family round is headed towards 250. It will then take up to 2 million to bring to market. Is this an angel round or a VC round? It sort of depends a little bit where you're located. I'm not sure where you're located. Out here, it could be sort of an angel or super angel or kind of band of angels type round. But if you're elsewhere in the country, there are VCs who play in that space. It's Tom from Berlin, Germany. Our company is registered in Palo Alto since 2012. I have health problems and disabled, and German headquarters in Berlin. We restarted in March 2021 with Berlin. We are a typical Delaware corporation. My question is, did VCs investigate in Berlin and then later San Francisco Bay Area too? Okay, yeah, let's talk later over email. I'm sorry, Tom. Please, yeah, let's connect live later. Done. Oh, my email again is jgordon@pulsonla.com. I'm going to send you an email if you registered, so don't sweat it. My email will also have my phone number on it. What is the role of the board seat position? Does he or she have any say in daily operation? Great to ask. So let's go over the rules in a corporation, and specifically a Delaware corporation. So what you've got are basically three types of, well, there are employees and consultants and stuff, but we're not going to focus on them. We're going to talk about the owners, who are the shareholders, and the shareholders have the rights to elect the board of directors and to get dividends when there are dividends. But early stage startups, there are no dividends, and even most startups, there are no dividends for quite some time. They elect the directors who set the policy, agenda, and direction for the company, and then it's the executives who carry those out. So that's the chief, CEO, CFO, secretary, vice presidents, those types of folks. It's those folks who oversee the day-to-day operation. Now, a person can have multiple hats. You can be a stockholder and a board member and the CEO. You could just be the board member and a CEO. So it's always important to keep in mind which hat you're wearing when you're performing things on behalf of the company, because you'll have different duties and obligations depending upon which hat you're wearing. But sort of generally speaking, in one sense, no, the board person doesn't have a say on daily operation, not on like a day-to-day thing. But in another sense, yes, they oversee the executives and they set policy when they act as the board. So they certainly have a right to understand what's going on, and you need to take their input seriously. Under the new Biden administration, can we expect to see easing constraints on Chinese investment and working with CFIUS and current requirements? So, there's a question on the Committee for Foreign Investment in the United States. In the last 2 or 3 years, there's been a substantial amount of regulation in that area, increasing regulation, focused primarily on limiting or overseeing investment by China. I don't know. I would think under the Biden administration, some things are going to change, but what specifically? I'm glad to be at a big firm again because we've got a CFIUS guy. I work with him all the time, and I would punt that question over to him. So the slides will be in the video that I'll send, so you'll be able to check those out. And what can we expect when it comes to legal counsel? Does the VC help out with that? So I think what you want to do is you want to make sure that you get connected to legal counsel that works and practices in this area, practices venture law on a daily basis. And then you want somebody who's going to be loyal to you and the company. It's possible the VC can connect you to that person, but you probably want to talk to 2 or 3 people and then make a decision as who's going to be the right fit. And then hopefully you'll get a good sense for who they are, and you'll build a long-term relationship. So that's my answer. I've cleared all the questions. We're rolling on to 8 o'clock, so we're going to keep pushing. So closing and post-closing issues. So here's what we've done so far. before you start your raise, you start thinking about how much of the company you're going to sell, what your capitalization requirements are going to be over the long term. You put together your plan for how that capital is going to get deployed. You've been building relationships with VCs. You then went out when it was time. You networked, you schmoozed, you got a term sheet. You got more than one term sheet. You negotiated the term sheet. You moved through the negotiation that got signed. You moved through the negotiation of the definitive documents. You took care of some cleanup that had to be done. You got through the diligence process. You're all aligned. You're gunning to close. Okay, you want the money in, wired in. So let's talk about how that happens. So typically what happens is there's either a board meeting or board consent adopting resolutions, approving the financing, approving the filing of the amended and restated certificate of incorporation, maybe adjusting the option plan, also known as an equity incentive plan. Those are actually two, not identical things, but we'll call them the same for tonight. You've then filed the certificate of incorporation or the charter. And then the closing can happen. And the closing happens basically, the lawyers are going to trade all the documents back and forth. They'll probably capture or obtain signature pages from everyone, and they'll hold them in escrow pending the release of the wires. The wires will come over and then everybody will sign off and the deal will be closed. You know, either before that period or after, the lawyers, usually the lawyers for the company, will put together a closing binder so that you have a nice packet of all the documentation that you did, at least related to the deal. And then there are things to do afterwards. So you've just sold securities, you just sold preferred stock. So you've got to file usually with the feds, and we can talk about going in stealth mode and not doing that a little bit later if you're interested. And you got to file with the feds, you got to file with the state, and the various states in which you've raised money. To the extent you were raising money outside the United States, you know, before you took in that money, before you made that offer to sell the security, hopefully you're on top of the securities laws in that country so that you're in compliance with that and you can take care of any filings there. Then you issue the stock certificates, and as I mentioned, you put together a closing binder. So let me share with you some real common pitfalls that I've come across time and time again, negotiating with VCs before you've run a proper pro forma. So that means before you've built that model of your cap table at the closing and after the closing, before you know how much money you need to raise in this round and the next round and the round after that, you start out there with a pre-money valuation. And you didn't really realize exactly how much dilution you were going to suffer. And it kind of is what it is. It's going to be hard to impossible, certainly at least with the same VC, renegotiating that deal after you've already set that stake, that psychological anchor. So you got to do that, and it has to be right. And in one sense, it's after you've done them, it's one of these things where it's really easy in concept, but it takes a lot of time to do. And I say that because frequently what we see folks having issued safes and convertible notes, maybe a couple different kinds of convertible notes. And every time you've got a convertible note or a safe, you got to take a look at the actual language about, among other things, especially if you're using a cap, what the definition of fully diluted basis is. And I say that because, as I said earlier, there's no real definition. Everybody defines it a little bit differently. And I have seen rounds where you've had 25 convertible notes that all look exactly identical, except for like 3 words or 4 words, and they're 3 or 4 critical words. So it's really detail work or detail-oriented work, but you got to make sure that you've done it so you know exactly how much of the company you're selling. Complying with the securities law. So there are a couple real issues here. One is you shouldn't engage in any securities fraud, that is make any false statement of fact or or omit any material information in connection with selling the stock, right? So you can't lie. You can't leave out information that if it was known, the investor would have made a different decision. You can't do that. The other issue that comes up, that's kind of the big one. The other issue that comes up, though, is each state has got different laws and different levels of protection. So zooming back for a second, the securities laws are really about protecting the public from entrepreneurs or not entrepreneurs, but nefarious entrepreneurs, hucksters, shamsters, who will go out there and sell fake stock or stock for a fake company that's never going to go anywhere, right? So there are different levels, and that's regulated both at the federal level and then at each individual state level. And so depending upon which state you're raising money from in the feds, there are different levels of protection that are afforded for different, for the investors, right? So if you're an accredited investor, I'm sure you guys have heard of that term, right? Most common, if you're talking about an individual, is an individual who is making $200,000 or $300,000 jointly with their spouse, whereas $1 million in assets, subject to some exclusions. They under federal law, if you're using a 506B offering, there are different information requirements that are required there. So making sure that you comply with them is critical, because the problem is not necessarily that you're going to be convicted of securities fraud and have to go to jail, but you may end up in a position that in order to fix this bust, that is, non-compliance, you've got to give the money back. And if the money has already been spent, it's no good. You're in a bad position. The other issue that comes up, and there's actually some regulation change in here, the use of finders. So finders are people who are not registered broker-dealers and who are connecting companies to capital. And there is some change in there, but it's still fraught with peril. And there are a lot of people, especially in the Bay Area, who do this, and it's not legal. And again, you end up in a situation where, one, like the investors don't want their money going to an illegal finder. So they sort of find out about it, and it's not something you can or should hide, because you have to make representations about it in the documents. They're probably not going to like that. And two, you could end up in a situation again where you might have to give the money back. Poor record keeping. So doing what I do is not most people's idea of fun, right? So corporate lawyers who are focused on making sure that you've got the books and records of the corporation straight. Again, not most people's tea party. So entrepreneurs, especially in the early stages where resources are scarce, by resources, I mean you don't have a lot of cash, often neglect their corporate books and records, especially as it comes to who has what percentage of, who owns what in the company. And one of the real problems here, this is a real pitfall, is that most of the time, and I do it too, many times when we're talking about bringing in somebody new into a company, we talk about giving them a percentage of the company. One of the real problems that comes up time and time again is that you will articulate a percentage, not document it, and then somebody else new comes in. Okay, so effectively the denominator keeps changing. And so it becomes very hard, very expensive, to go back kind of in time and figure out who had what then. And if the person doesn't agree with it, then all of a sudden you potentially have a lawsuit or a threat of a lawsuit on your hands. So that's one of the issues. That also goes with the napkin promises, right? And that is, maybe you've got a buddy who you sit down to have drinks with at a bar or something. You tell them, oh, I've got this great idea, blah, 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 blah. They give you some input. You say, gosh, I'm going to give you 10% of the company for that. You write it down on a napkin and give it to them. That, believe it or not, does happen. And it shouldn't, but it's kind of the ugly cousin to poor record keeping. Okay, so we're at 10 after 8. I've moved through all the material. There was a lot. I hope that has given you a good sense for for how to do a venture capital financing. I'm going to turn my attention now to the questions to see if we've got any. We do have one, and answer any other questions that come up. After 8 years, me and my partners have built a practice management software for medical providers, not an MVP. It's a full product. My partner and I have 50-50. He wants out and is willing to give up all his shares to me. We have 3 months of runway left and are burning $5K a month. We need an angel, it seems, as we are a lean startup. How significant is it that my team is limited to me and a team of programmers? Can an angel help me with a team? We have some customers. We have some customers who are just starting our funnel. We've spent $225,000 in family loans. And we're acupuncturists based in Oakland. So I think, that certainly is in the dollar value of an angel raise. I think, before you could raise money from an angel, you would need to and want to, and maybe you already have, put together a business, put together the nuts and bolts business plan of how you're going to take their $250,000 or whatever it is that you're going to raise, and how that's going to get the business moving. Because if you're just talking about having your partner bought out, maybe you're looking to have another partner come in, and that's a little bit different than sort of an angel as a bridge to the VC raise. What is the VS attitude towards EU public funding that a startup has applied for? I think that's probably transposed. I think it's probably SV. Okay, so what is the Silicon Valley attitudes towards the European Union public funding that startups applied for? So from what I have seen, and I'm not a venture capitalist, but VCs do like to have their money leveraged, and do like to, that is, see government grants, whether they're US grants or EU grants, see those dollars come in. I say that provided that the IP is still either unencumbered or relatively unencumbered. That is, you'll still be able to freely commercialize the IP such that you'll be able to get the return that the VC wants. So I think, by and large, whenever I talk to VCs about it, they like seeing their money leveraged. Opinion about new tech hubs like Miami having new big player moving out to Silicon Valley to Miami like Keith. Look, I love that tech and venture is moving all throughout the rest of the United States. I embrace that. I'm cut from a little bit different cloth. I came from Pennsylvania originally. I'm not from the Bay Area. So my opinion of it is great. The world, especially with Zoom, is becoming flatter and flatter. Capital, by and large, except for some of the CFIUS stuff, which we talked about, is able to move around. And I think by and large, it's good for humanity in order to have capital allocated in places outside of the Silicon Valley. So I embrace it. I think it's great. Additionally, my firm, has offices in Miami. We have offices all throughout the rest of the United States. So I think we're really well positioned there. What about overseas foreign-based investors? Which country laws leads, or is it relevant? So I'm not sure exactly what this question is about, but I think the question, but I will answer the sort of the analogous question to the one which I just answered, which is, again, I think it's great that tech and venture are becoming a global phenomena. I only see more of it happening. I know that Silicon Valley investors will invest overseas in Europe, in Asia, in Africa, in Australia, and vice versa. And, by and large, especially if we're talking about, tech and software, all that can be zipped around the world in a nanosecond. And so these are really global markets. And so long as you can articulate a convincing, real business proposition and business plan as to, why their money is good money to take and why you'll be able to realize the kind of return that they want, I think that, you will be able to gain some traction with them. Now, let me go back to just some basics, which we touched on before, because I think it bears repeating. You need to do your diligence on these investors. You want smart money. So you want investors that are going to bring not only dollars to the table, but also potential opportunity to give you input and advice, to open up doors and make connections. And, it might be harder to do outside of your country, but it's definitely not impossible. Oh, what court do you end up if there's a dispute with a foreign national? Okay, no, that's a great question. Okay, so look, I'm not an international litigator, and international law is, especially as it comes to this, can be quite tricky. Usually what we build in are choice of law provisions and forum and venue. And so theoretically, the contract is going to dictate how you're going to resolve that dispute. We would build that in a contract. Now, enforceability is a different matter as to that, and whether or not you'd actually be able to sort of execute. And it's going to depend on the country where they're at, as to whether or not there's reciprocity between the countries. So, again, what you usually try to do when you're making a contract with a foreign national or foreign entity is choose the choice of law, choose where a dispute is going to be resolved. And when you do that, you need to take a look at the country and you need to figure out, is this going to be enforceable if for some reason there's a dispute? So in other words, if you end up in a dispute and the foreign national is somewhere else in the world, but your choice of law and venue is here, how are you going to compel them to come here? And so some countries have some treaties and reciprocity that will allow you to do that, others don't. So it'd be much harder. Oh, I'm glad. So I just got a positive statement from someone. I'm glad that you are finding this helpful. So it's kind of hard to do these sometimes just into a camera. So that's good. I apologize if my question is covering during the session as I joined late. Many companies keep losing large amounts, but are still gaining large investments based on future potential. We can see the future is predicted well now. So Alan asked a question, I think, about large investments, I'm presuming, in startups based on future potential. Again, the sort of venture model, whether it's from a traditional venture fund or even corporate VC, is usually about high risk, high reward, right? So putting in some money into a bunch of different startups where most of that money is not going to make it, but maybe 1 in 10 or 1 in 20 just knocks it out of the park with like 100 times return. So yeah, you're going to see capital deployed in that manner, I think, for quite some time. VCs, there are a few things that they do to try and control some of those risks, or to mitigate them, if you will. It involves not giving you all the money that they have up front. So that's why you see this sort of round step mechanism, right? They want to see what you can do with the initial money that they put in, but they usually have another round or two of dry powder to put in later. They sort of find syndicates and will go in with other VCs so that they're not putting in all the money into the company. And that does two things. It allows them to, well, does at least one thing. It allows them to spread the risk with other VCs and also saves their money so that they can make some of those bets in other companies, allows them to further diversify. So I think this will continue, in part because there is, and I haven't seen the reports yet, but as I understand it, there's record levels of dry powder that is capital that is yet to be deployed under VC management. And there are seemingly record number of corporate VCs and other non-traditional players in this space, all hungry for these returns. So I think a lot will continue to, I think capital will continue to be deployed in this manner. How to address living expenses in early stages? Are there alternatives besides a second job? So this is kind of tricky. I mean, one, you need to make sure that you can eat. And if you've got a family, you got to make sure they can eat. You got a roof over your head and their head. There's nothing wrong with struggling a bit, doubling up in a room, with a roommate or living at home to make it. If that's what's going to take to get your idea going and off the ground. But certainly by the time you get to the A round, unless you are a previously successful entrepreneur or you've got some sort of other X factor, you're going to need to be fully engaged, working full time for the business. So, how you are able to make ends meet. Unfortunately, I think most investors would take the position, before they put their money in, that's kind of your problem. When they put their money in, yeah, they want you to be focused, right? So that you will get paid, but it may not be handsomely because they want to keep you motivated and hungry to get a great return for them. So someone said that they're a couple of years away from starting a business, but this is good. Yes, file this information away. It's never too early to start learning this, at least just kind of starting to absorb it. Oh, we got some more props. Thank you, everyone. VCs or angels, which one is more sustainable for a tech startup? So these are not choices of either an or. In the traditional sense, these are not choices of either or, an angel or a VC. So an angel, at least in this space when we're talking about venture-backed companies, an angel is somebody who's got a lot of money. Maybe they're a previously successful entrepreneur. Maybe they just like the space and they're out there deploying their own funds. Or maybe they have other angels that they work with and they deploy funds kind of together. To usually in the sort of seed stage. So when you're building the initial prototype, you're putting the initial team together. They're kind of a bridge to the VC stage where the company already has a prototype, already has a team together, and is already starting to get some revenue and some traction. So it's not an either or which one is more sustainable. It's usually a point in time, and can you get past the VC the angel stage. In other words, angels are more typically kind of betting on the team than they're betting on the technology in that market. I have a startup involved in import of products, basically in a marketplace. Can this be eligible for funding? So at the very beginning, maybe the second or third slide, well, let me rephrase that. In the model that you've built for your startup, is it reasonable that an investor, if they put in $5 million, would get a 10x return over 5 years? If so, then maybe. But honestly, if it's just that kind of, if you only need $5 million to do the business, usually VCs are in the process of putting in a lot more than $5 million. It'd take 20, 30 million. When a company is pre-revenue, what are some of the top ways that the company is valued? So that's a great question because it's kind of impossible to answer. Traditional valuations are done looking at comparable companies, seeing what they sold for, looking at discounted cash flow method, those types of things, which are, well, the comparable one is not dependent on revenue, but the cash flow method is. And so it is a bit of a crapshoot. That's one reason, and this is not this presentation, but usually in the seed stage, when we're talking about building that initial prototype and that initial team and the initial go-to-market, we are talking, I recommend using a convertible note or a safe, so you delay having to value the company because you really don't know what it is at that point. So in one sense, when you're doing it, when you're selling preferred stock, whether it's a Series C or a Series A, the price is whatever the price that you are willing to sell it for, and that someone else is willing to buy it for. There's not really, I did come across a guy today actually who says that he does valuations for companies at this stages, but those folks are few and far between, and usually that's not how it's typically done. How would you evaluate and select angels and VCs if you're talking to several of them who are interested in investing? So what I would do is again, we talked about some of this before. You want smart money. You want people who work in your space that have a good reputation for bringing value to the companies that they invest in, whether it's connections, whether they're known to be they work well and for the companies, and if tough times are hit by the companies, they stick with them. I'd be looking at those types of things. And there are some diligence things that you can do to ask some of those questions and to get some of that out. Some of the things, and it's funny because I was just reading an article today. You may want to get a sense also for whatever their other time commitments are, right? So if you got a VC who serves on 25 boards, they're probably not going to be able to serve that frequently on your board or be that hands-on. And do you want that? Don't know. You probably want people who have worked in the space that you're in or an adjacent space and have done it successfully before, because then they can bring real experience to the table and when they give you their opinions and input. It's not necessarily an either or with regard to angels. I mean, angels can participate in a venture round, right? They can be some of the capital that comes in the door, but they're not, they're not going to be leading it by any stretch. So I mean, I would think about what their time commitments are, what their reputation is, try and get a sense for whether or not they've worked in that space, how extensively, whether or not they can open any doors. Those are the things I would be taking a look at. Do you have any advice for getting funding for a fashion company, or is there no specific advice for that type of business? I think fashion right now, is in the consumer space, which is a hot space, which we do a bunch of work in the consumer space more broadly. I think it's about this, a lot of the same sort of fundamental issues come up, which are making sure that you are getting in touch and pitching VCs and growth equity firms and angels that are active and working in that space and can open doors for a couple of reasons, which also include if you're trying to pitch to an angel or a VC who's not in your space, they're not going to understand the market and your go-to-market strategy nearly as well as someone who's been in that space. So I'd be interested in chatting with you about what you're working on in the fashion industry, see if there's anything I can do to help. But I would certainly be focused on fashion-specific angels, VCs, and growth equity folks. I have a design for a folding table and a folding chair. Do you think angel investors or VCs will be interested in this kind of product other than tech-related products? Again, I mean, that kind of goes towards in the consumer space. I think there is, but that business case needs to be put together, right? If someone puts if in the aggregate you need 25, 30, 50, $100 million to grow your company, are they going to get a 10x return in 5 years? What does that model look like? Now, there are other alternatives too, in terms of if it is really very innovative and is very user-friendly and no one's ever really thought about it before, if you patented it, you might be able to do a licensing deal and you wouldn't necessarily need all that capital. So there are a couple of different plays to be had there. Super. Well, I think that's about it. We've run through the questions. All right, so one last question, which is always a perennial question, which is worried about sending pitch decks to VCs without an NDA or maybe password protected DocuSign program. Sometimes I can wax poetically on that topic for like 5 minutes, but I'm going to just distill it really quickly. And then we're going to call it a day. At least out here in the Bay Area, unless you're in like a life sciences company, you're probably not going to be able to get an NDA in place with a VC before you get a term sheet. Now, and even after you get a term sheet, you're probably not going to get an NDA in place with a VC. So one of the best things you can do is control the information that you are giving. So don't give highly confidential information at this point. Especially if you're kind of doing a cold call, it should be a teaser. It shouldn't necessarily be the full thing. Additionally, when you need to understand that they've got portfolio companies, and some of those portfolio companies may be your competitors. And if you've done a good job researching them, you'll know that, right? You'll know who they invested in already, and you'll say, oh, well, probably doesn't make sense for me to pitch a VC that is already invested in my competitor. So you just need to be mindful of that. And that's kind of the best way sometimes to prevent this from being an issue is just not giving them all, don't give them super highly confidential information. It should, to the extent it is confidential, it, should say that, and you should take some steps to try and get them to not disseminate it, whether that's labeling as such or whatnot, but you're just not going to be able to get, an NDA in place, at least out here. All right, and it looks like Brian Drunkchef has a question, which I'm just not going to be able to get to, but you can send me an email, jgordon@pulsinelli.com, and we'll do some office hours. Done. All right, well, thank you very much for attending tonight. I'm Jason Putnam Gordon at Pulsinelli LLP. My email is jgordon@pulsinelli. I want to thank Rob Lau and Idea to IPO, along with Jennifer Stowell, who introduced me. I want to thank each of you for attending today. It was a lot of fun. Happy 2021. Stay safe and be well. Take care. Bye-bye.